What, do we have everybody from Pittsfield PD here? Does Pittsfield have anybody on the road? I mean, I'm just thinking,
The fire department's here.
yeah, everybody's here. You guys take care.
Welcome to another intense day in Judge Simpson's courtroom, where calm composure meets legal chaos. Today's case, Finney versus Sidoni, may sound like a typical landlord-tenant dispute, but as the minutes unfold, this hearing becomes a collision of fraud accusations, emotional tension, and procedural drama. Watch closely as both sides scramble to gain footing before a judge who doesn't tolerate excuses. The stakes? Claims of fraud, unpaid rent, and thousands of dollars in contention. The air is thick with tension from the very start. Every word from the attorneys could shift the outcome. This is the kind of courtroom energy that shows exactly why preparation, timing, and precision decide who walks away victorious.
Thank you, Mr. Schiller.
Thank
Um, Mr. Schiller, can you approach on a separate matter? Or that's called the case of Finney versus Sidoni. The first thing, you guys are gonna have to switch sides. State your appearances, please.
Good morning, Your Honor. This is Megan Dogwalla on behalf of the plaintiff, P84205. Mayor, can you state your name?
My name is Maria Finney. It's Sidoni.
Peter Sidoni.
All right. It's a date set some time ago for a non-jury trial. Are the parties ready to proceed?
Your Honor, may I approach the bench and go off the record briefly before I begin? I have a procedural issue.
Right from the jump, the plaintiff's attorney throws a wrench into the proceedings, a procedural issue on the day of trial. Judge Simpson isn't impressed. Lawyers know procedural motions belong before trial, not during opening minutes. It's like showing up to the game and arguing the rules after kickoff. But here's the twist. The attorney claims new evidence of fraud upon the court, and even insurance fraud. That's not a small accusation. Fraud claims demand rock-solid proof, and Judge Simpson wastes no time making that clear. You can sense his patience thinning as he warns, "You better bring it." Moments like this reveal why courtroom discipline is everything. One careless claim can flip a case or a career.
A procedural issue?
Yes, I can stay on the record.
That's fine.
Oh. May I-
What? No, well, then I've got to have them up here.
Sure.
I guess, what is it?
Okay, so there is a counterclaim, which is what this is separate full trial. There was already an order of eviction entered. I'm intending to move for summary disposition under C8 and C10. I need the opportunity to brief that issue.
Well, why am I here on the date of trial with that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. So please, Your Honor, I'm not appreciating that for its time. However, I'm recently retained, and there's about 1,000 pages worth of evidence. This has gone to mediation. There's conflicts in the facts, even in what was submitted during mediation, and there's significant evidence indicating issues of fraud upon the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MCR 2.116 C8 and C10.
Well, the motion should have been brought before today. I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it. And it better be that, because if it's not, then I'm going to be exceedingly angry, because I don't like people. I do not like people accusing others of things like that without substantial proof.
This is pure Judge Simpson, firm, sharp, and unfiltered. When he says, "You better bring it," he's sending a message to every attorney in the room. Evidence or silence. Judges hate when accusations fly without hard proof. It undermines the entire process. But what's fascinating is how this moment shifts the courtroom's energy. You can almost feel everyone holding their breath, waiting to see if the plaintiff's attorney can actually deliver. This kind of tension, accusation versus authority, is what makes courtroom drama magnetic. Viewers, what's your take? Do you think the attorney was justified bringing up fraud this late, or is it just strategy gone wrong?
Absolutely. It is a substantial issue in this case. My client's rights have been significantly violated. It's
By whom?
by former tenants. This started out as a non-payment of rent case. As I mentioned, there was an eviction action, there was an order of eviction. As you're aware, we're here on the bench trial for the counterclaim. I don't take a claim of fraud upon the court lightly. There is significant evidence to present that. And I don't want to disparage my client's rights by not attempting to have this dismissed under C8 and C10.
Well, I get it, but there was an attorney in this before.
He's exceedingly difficult to get a hold of. That was part of why I asked to approach the bench, but
He's
I understand
been
there's
held up. He was in court here Monday, so I don't know
Okay.
why he's not that difficult to get a hold of.
okay.
Coming in on the date of trial, asking for an adjournment of these proceedings is not going to happen.
Judge Simpson's patience snaps, and rightly so. Imagine preparing a full trial only to hear someone wants a delay. The courtroom isn't a revolving door for unprepared attorneys. His tone here is the embodiment of judicial discipline. Trials move forward, no excuses. What's compelling is the subtle test of professionalism happening in real time. The attorney tries to regroup, requests a recess, and the judge grants it, showing fairness despite frustration. It's moments like this that separate emotion from procedure. Even under pressure, Judge Simpson knows when to assert control and when to allow strategy to play out. This brief pause could determine how the rest of the case unfolds.
Okay.
So you guys either can try to resolve this thing, or we're going to try it.
Okay. Fair enough. Then I would request a brief recess to please speak to the defendants.
Okay, see if you guys can work it out. Court's going to stand in recess.
14A District Court back in session, the Honorable Jake Senator Simpson.
You may be seated. Back on the record, court does call the case Finney versus Sidoni. All the parties are present, and how did the conversation go?
It wasn't entirely productive, Your Honor. So we have back from 2021 a consent order for conditional dismissal. There was an eviction order entered after that time against the defendants. As it relates to today's full bench trial, it is based on a counterclaim that was filed on February 12th, 2021. However, again, it's my position that the counterclaim needs to be dismissed. There's not actual cognizable claims under the counterclaim, so that it would be right for dismissal under MCR 2.116C.
Why are they not cognizable claims?
Now the legal technicalities kick in. Cognizable claims basically means claims that the court can legally recognize and rule on. The plaintiff's attorney argues that the counterclaim lacks valid grounds, but her reasoning is shaky. She references procedural dismissals and conditional orders, but doesn't anchor them in strong case law. Judge Simpson senses it instantly. He wants case law, not abstract explanations. This is the beauty of judicial sharpness. No fluff, no filler. He's cutting through the noise, demanding clarity. Watching this, you see how a lawyer's preparation determines credibility. In legal battles, vague arguments sink faster than lies.
The claims are not cognizable, as defendants are now pro per in this case. This was filed by their previous counsel. There is not a cognizable claim in regard to the condition of the property as against my client for relief.
Why is that not cognizable?
Can you repeat the question?
Why is that not cognizable claim?
It's not a cognizable claim, Your Honor, because there is a conditional dismissal entered as it relates to the original complaint where the defendants were being sued for the non-payment of rent, where the counterclaim asserts a generalized claim without any sort of reference to a breach of habitability or constructive eviction. The way that it's written in this counterclaim, it's more pertinent to the affirmative defenses, given the case history here and the fact that there was an eviction order entered. At this time, this can't be a cognizable claim before the court.
That doesn't even make any sense. If somebody says I paid $1,000 or rent was $1,000 a month, I didn't pay the $1,000, and actually I was living in conditions that I think the landlord may owe me money because I paid them or something happened to the unit. The very fact that there was an agreement to vacate the premises doesn't negate their claim for money. As it wouldn't the landlord, if the landlord had a claim for money.
Absolutely, Your Honor. My point is more towards, to back up slightly, this has been in court for a long time. There's a lot on the record, especially for something that started out as a non-payment of rent case. The defendants are the relatives of the plaintiff.
I'm aware.
There's
I'm aware of a whole lot in this case.
There are facts in the counterclaim that are very generalized. There's not a factual section or actual claims after that. It's very generalized, but it does assert that there's a dispute as to mortgage payments. There's a dispute as to ownership interest. So this is out of the realm of a landlord-tenant non-payment of rent case. And it's not a cognizable claim under the statutory law for those damages. Secondly,
You keep saying that. Give me some case law that says that.
Okay.
Here's a masterclass in courtroom reality. No matter how confident your tone, if you can't back your words with precedent, it means nothing. Judge Simpson's demand for case law is the classic lawyer's test. Support your argument or stand exposed. The tension here is palpable because the attorney, clearly unprepared, tries to pivot to another point instead of answering. That hesitation? Fatal. It shows the gap between rhetoric and readiness. Legal viewers, let's be real. Would you ever make a motion without precedent ready to cite? And for everyone watching, what's your take? Was the judge too harsh or just upholding courtroom standards?
May I move on to a second point briefly and then return to that, Your Honor?
Go ahead.
Okay. Secondly, after the generalized facts in the complaint, then the defendants move on to enter under a claim of statutory conversion, common law conversion, excuse me. Well, okay.
Regarding the insurance money.
It's both. In paragraph 28, it's combined into common law conversion and conversion under MCL 600.2919A. Now, again, of course, Your Honor, we're considering what the language actually is in the counter complaint, but it's to my point that these claims are entirely convoluted. But they're asking for, as you would be entitled to under statutory conversion, 3 times the amount of actual damages plus costs and reasonable attorney's fees. If there's no summary proceedings to be had in terms of the possession of the property, and what's at issue here are ownership interests and statutory conversion claim that exceeds $25,000, it's in the beginning, as I was arguing to you, that this would be appropriate for dismissal under MCR 2.116C7. However, even if
Jurisdictionally or under 7? Why under 7?
right, this is what I'm stating, Your Honor. In the beginning, maybe it wasn't helpful to move on to a different issue, but in the beginning, it's that there aren't cognizable claims that apply any longer, given the procedural history. Not only that, but also just the way that it's been written out here in terms of the habitability. I did need a brief moment to consult my information, but in terms of the habitability, the actual counts that would indicate that the legal requirements have been met are not enumerated. And then secondly, it would be appropriate under MCR 4.002, not necessarily to dismiss the action, but if it's related to property ownership, which is quiet title, and if it's related to conversion for a claim of over $25,000, it's not the court's obligation to dismiss it, but it would be more proper that this be transferred to the circuit court.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case.
The attorney's attempt to transfer the case to circuit court crashes instantly. Judge Simpson's response, "I'm not removing this case," is definitive and cold. Here's why that matters. Circuit courts handle higher value or complex property disputes, but Simpson sees this as a stall tactic. The judge reminds her he's already clarified jurisdiction limits multiple times. Translation, "You knew my boundary, don't test it." This is where experience shows. The judge won't let confusion derail progress. Lawyers often use jurisdictional arguments to buy time, but here, that strategy dies fast. This moment reveals a theme running through the trial: delay versus discipline. Which side are you on? Should a new attorney be granted leniency, or is the judge right to keep momentum?
I think it was, and you coming late to the game. I think I explained to the Sidonis I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was 25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. Anything else?
I mean, I have to object to proceeding on a full hearing at this time.
On what grounds?
The numerous reasons I've stated.
You've stated a lot of gobbledygook is the only way I can explain it. You haven't given me a reason. You haven't given me a reason why it shouldn't proceed today.
The courtroom tone shifts from debate to confrontation. Judge Simpson has had enough of legal gymnastics. His phrasing, "You haven't given me a reason," is judicial code for "you're out of arguments." It's both firm and final. This exchange shows the invisible power dynamic in court. When logic collapses, authority speaks. The attorney pleads for fairness, saying she only wants to do right by my client. But by now, the judge's focus is on progress, not persuasion. This tension between empathy and efficiency defines Simpson's courtroom style. And let's ask the viewers, do you prefer judges who are empathetic and patient, or strict and result-driven like Simpson?
This matter has been set for trial today. I have given a lot of leeway to both parties, I think, in terms of trying to make sure to try to resolve this case, to try to find a way to do it, sent them to mediation. They went through basically a mediation with me regarding this case on a couple of occasions. And it's come down to the date of trial. And now you come in wanting further delay. And I'm not delaying this.
It's not that at all, Your Honor. I just want to do right by my client. I was hoping I could approach the bench. I understand there's not another attorney, and a party also have to be able to. But I would like to go off the record for a moment if it's acceptable to you.
Do you have any objection to that, folks? No. All right. I don't know how we're going to have this conversation, but let's do it this way. We can go off the record. Mr. Trapp, take both parties and behave yourself when you're in my hallway. Take them back to the jury deliberation room. When you're seated in the deliberation room, I don't want either one of you saying anything to anybody until I get there. We clear? Ma'am, am I clear, Miss Finney? All right, take them back to my jury deliberation room. And the court will stand in recess. My understanding is the parties have had further discussions. Did anything come out of that, or are we still?
Yeah, Doctor.
Sure.
When we came back in, she asked us to step out in the hallway. And when we stepped out in the hallway, she proceeded to tell us that pretty much if we don't take the $5,200 in escrow and walk away today, that she's gonna file a lawsuit against us in a different court, that you won't be our judge, and it'll be over $25,000.
The hallway negotiation explodes into open court. The defendants accuse the opposing counsel of coercion, saying she threatened a new lawsuit unless they accepted $5,200 and walked away. Whether or not it's true, that accusation instantly adds heat to an already volatile room. Judge Simpson immediately moves to stop this from becoming a sideshow, reminding everyone that settlement discussions shouldn't be aired on record. What's fascinating here is the psychology. Under pressure, both sides expose their frustrations. It's human, it's messy, and it's why courtroom cameras are so captivating. This moment shows how emotion can sabotage strategy in seconds. Question for the audience. If you were the judge, would you allow such claims to be voiced publicly or shut them down immediately?
So no money matters. She didn't want to talk about the money matters again. So she said escrow only. So I just leave it in your hands, Your Honor. I don't know what to do anymore.
Completely misconstruing what I said. And we shouldn't even be talking about settlement matters, but I made a valid settlement.
Counselor, if you don't want to talk about it, don't talk about
Yeah,
it. It's not going to make a difference to me.
right.
I mean, I'm just going to say this. I mean, we go back there and talk. Your client, I'm going to let you put the testimony on, but there are certain representations that she's made to this court that you may or may not be aware of, because you got caught with one. I'm not saying caught in the sense of whatever, of a statement that she made, which is absolutely contrary to what she said before.
Right.
All right, are we ready to try this?
To be let off the case at this time?
You're looking to withdraw?
Yes. I can't reasonably represent her if I'm going to misconstrue the facts.
The attorney drops a bombshell. She wants to withdraw from the case mid-trial. That's almost unheard of. When a lawyer publicly declares they can't represent a client due to conflicting facts, it signals complete breakdown of trust. Judge Simpson recognizes this immediately. His reaction is measured yet sharp. He points out that contradictions have surfaced. Statements made earlier don't match today's testimony. This is one of those rare moments where the judge shows restraint instead of anger. He pauses proceedings, telling counsel to have a detailed conversation with her client. Behind that calm tone lies deep frustration. Legal viewers know this is a defense unraveling in real time.
Well, it's not an issue of you misconstruing the facts. I'm just telling you that there have been certain representations made on the record, which I will tell you were different than what was said today. And I will tell you, counsel, I can tell by your reaction that you did not know that. So if you are going to move to withdraw, I'm going to step off, and you probably need to have a detailed conversation with your client about that. The court's going to stand in recess. Everybody can remain seated.
All rise. 14A District Court back in session with the Honorable Jake Simmons.
You may be seated. Court does call here we call the case of Finney versus Sedona. Parties are present. The record should reflect I've had an opportunity to talk with the parties, and parties have come to a resolution. I'll state it on the record and then ask for the concurrence that that is the agreement. Parties have agreed to a full and final settlement of all claims that could have been raised in this case or have been raised in the amount of $10,000. That will be in favor of the Sedonis. That $10,000, the amount of $5,263.17 will be released to the defendants from court escrow. The remaining amount of $4,736.83 will be paid by Ms. Finney to the Sedonis in monthly payments over a 2-year period. And counsel, that amount, what was the amount per month that you came up with?
That was $197.33.
All right, per month for 2 years. When did she wish to begin those payments?
Next month.
April? Okay. Is there a particular date in April?
I think the 30th.
The April 30th? Would that be acceptable to? All right. Beginning April 30th, 2025, until that is paid in full. Should the defendant miss a payment, default on the payments, an additional amount of $5,000 will be added to the $10,000 figure. The Sedonis would then be entitled to a judgment in that amount, less any payments, which is inclusive of the escrow that have been made. All right. Also, I am the oral motion of counsel to withdraw once the order has been prepared. I will grant that, so that after that, the order is signed, she will have no further obligation to this case unless she undertakes it in some other way. That's the court's full understanding of the agreement of the parties. I'll start with you, Ms. Finney. Is that your understanding?
Yes, Your Honor.
Do you have any questions whatsoever regarding that? And I will ask this because of what occurred. You are satisfied with the efforts of your attorney in representing you today in this matter?
Yes.
All right, great. To the Sedonis. Mrs. Sidoni, is that your understanding of the agreement?
Yes, sir.
Do you have any questions regarding that agreement? And you are satisfied with that agreement? Mr. Sidoni, is that your understanding of the agreement?
Yes.
Do you have any questions regarding the agreement? And are you satisfied with the agreement? All right, very good. I will await the order, then I will sign it. I will thank all of you for working this out today. It has been a long haul, but I think it certainly has resolved in the best interest for all of you. And I wish all of you the best in the future. All righty. Thank you.
Thank you so much.
After hours of tension, Judge Simpson finally steers this chaos toward resolution. The settlement, $10,000 in favor of the defendants with structured payments and escrow release, ends a long and emotional saga. Both parties agree, visibly exhausted but relieved. What stands out is how the judge balances firmness and closure. Despite arguments, mistrust, and procedural confusion, he maintains control until both sides shake hands on final terms. This case underscores why courtroom order matters. Law without structure descends into chaos. It also reminds us how patience, not aggression, ultimately drives justice. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns on Trial Truth.